Hi, friends. Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today.
Well, it's another day, and I'm feeling a little bit better. I think my voice is a little bit better. This has been a little harder bout than the first time I had COVID. First time I had COVID, it was no big deal. This last one was kind of a nastier bug. But I'm on the mend, so let's move on into another of your favorite kinds of cases, lawyers behaving badly, or in this case, lawyers who wanted to be judges behaving badly. There are some people who are drawn to the practice of law, not because it's an opportunity for public service, not because they want to help clients, and not because they want to help set public policy in the state where they practice. They are drawn to it because it affords them an opportunity to obtain money and power. And there are people who simply crave money and power and really don't care how they go about getting it. There are just some folks who, even if it would be easier to just tell the truth, even if it would be smarter to just follow the rules, and even if the gain of taking the lower path is not worth the risk in the long run, they will always default to deceit and self-destruction because that's the way they're drawn. My old boss used to call them angle shooters because they were always working on an angle. They had an angle on something in everything that they were doing. One thing I learned as a clerk at the Supreme Court, and of course I see it taught regularly on here with Fridays with Frank, is that it is much better to be on the mountain of right than in the valley of wrong. But to quote a song by Ray Stevens that I've mentioned on here before, Blue Cyclone, some guys never learn. And so, rather than be an honest lawyer, they aim for the low road. Robert J. Ringer, in his book called Winning Through Intimidation, called lawyers the masters of the croupier stick. I read that book in high school, and I'd never seen a croupier stick. The closest I'd ever come to a casino was watching James Bond. And it's that little hook thing that the guy at the craps table uses to retrieve the dice and the chips and that kind of thing. He said that lawyers were the masters of that croupier stick because no matter who wins or who loses, the lawyers always win. Now, obviously, he was talking about corporate lawyers, which was sort of his experience. Because when Acme sues Ajax, they have to hire lawyers to do that and sue them for trade libel. And when Ajax gets sued for trade libel, they have to hire lawyers to defend them. And then the lawyers get together and they bash it out in court, and they both bill both companies by the hour. And at the end of the day, no matter which company wins or loses, the lawyers do pretty good. That's not the kind of practice I ever wanted to have, and I'm glad I didn't have it. Robert Ringer is right when he talks about corporate lawyers being the winners when, no matter who wins. But that's not true of personal injury lawyers because we only get paid when we win, and sometimes we lose pretty big. Now, there is a subset of lawyers called property lawyers, and these are the people who operate title companies, title insurance companies. And they're the place that you go when you have a closing on your house or on your business or some kind of a property sale. And they sell the title insurance. They make a little money at that. They get a legal fee for reviewing and sometimes producing the paperwork for the real estate sales. They don't get million-dollar verdicts like I did, but they also have a steady stream of income to worry and live comfortably without having to worry about betting the farm on the outcome of a particular case and maybe losing. Well, the guy we're talking about today was a property lawyer, and apparently he didn't get the memo on the whole idea of perhaps just being happy with a steady stream of income that you worked for, because he sought higher office, specifically a judgeship, which is probably exactly the last thing that he should ever have gotten. Well, he did get elected, and he lasted all of 3 months on the job. This is a story of Miguel Mirabal, a Miami lawyer who, according to the Florida Supreme Court, from which all of this information is drawn, the opinion is public domain. That's what I'm basing my opinions here on. He had a real problem telling the truth, as the opinion is going to show you. I want to point out that Florida does bar discipline and judicial discipline right. They don't mess around. They put judicial discipline on blast. They bring in the judge and they rebuke that judge to his or her face. And with respect to the lawyers, they also take no prisoners. Oral arguments are on their website, and you can view the oral arguments on YouTube. Lots of transparency. And if the bar was going to hand out sweetheart deals, you'd know it. But in this case, even though the opinion never mentions it, that's exactly what the Florida bar tried to do with this discipline case. Early on, they entered into a consent judgment with Mirabal for a suspension, and then they sent it up to the Florida Supreme Court, who said, "Are you insane?" Listen as the appellate advocate for the lawyer details what
Okay,
happened.
we'll now take up our last case for today, which is Florida Bar versus Mirabal, number 2021-1469.
For purposes of background, the proceedings are after the Florida Bar filed its complaint, knew all of the facts in support of its complaint. Florida Bar and other counsel for Mr. Mirabal consented to a 90-day suspension with probation. The referee, same Judge Casey down in Fort Lauderdale, referee judge entered a 20-page opinion, facts and law, in support of that 90-day suspension. This court rejected it, remanded it down. Back in December, there was 3 days of hearings on the matter.
So this is the Florida Bar versus Miguel Fernando Mirabal. And this is a per curiam opinion, which means it's the entire court. No one judge is writing it. We have a review of a referee's report recommending that this guy be found guilty of professional misconduct for repeatedly certifying as correct campaign finance reports he knew were false, making material misrepresentations and omissions in his application to fill a judicial vacancy with the Judicial Nominating Commission, and for his misconduct during these disciplinary proceedings. And they note that they have jurisdiction under the Florida Constitution. So, in 2017, this guy, Mirabal, decided to run for election to a county court judgeship in Miami-Dade County. He initially designated himself the campaign's treasurer, but later he hired Janet Garcia, a certified public accountant who handled accounting matters for him. Now, Mirabal was required to regularly file campaign finance reports with the Miami-Dade County Elections Department. He was required to certify the correctness of each report, and he supposedly personally reviewed and certified each of his campaign's monthly reports using his unique pen. The referee found that Mirabal's campaign finance reports were riddled with material errors about his campaign's finances, many of which were likely timed to be politically beneficial to his campaign. In essence, what he was doing was he was trying very hard to indicate to other people who might be thinking about running in these races that he had a huge war chest and, he could easily beat them. I'm not sure it worked, but at any rate, that's what his, I think, plan was. At least that's what I gleaned from this opinion. So here's what he did. The referee found that he, just before switching races from Group 18 to Group 43, he made a series of amendments to his campaign's reports that made it appear to the public and others in the race as though he had a larger campaign account balance and was much better funded a candidate than he actually was. And then after the qualifying period ended, he amended the reports to decrease the balance of his campaign account. Now, we don't need to go through all of this, but basically, when he started amending, he added $196 and collected cash and checks and reported $46,000 in his campaign. And then over the next probably 2 hours, he continually amended his reports to show that he actually had a campaign balance of $71,829.72. Then, minutes after the qualifying period ended at noon on May 3rd, Mirabal amended these reports to delete the doubled $3,130 in cash and checks and delete a $3,421 purported loan from himself, lowering the cumulative total of the campaign account to $69,278. 10 minutes later, he made another change that lowered it to $59,000. 62 minutes later, he amended it to delete a doubled $20,000 purported loan, and it lowered his cumulative total of the campaign account to $39,000. So based on these numerous material errors in his monthly campaign finance reports, the Florida Elections Commission, in a consent order, which means basically they charged him with this, and he then essentially entered into an agreement with them to pay a $2,000 fine. When asked at the final hearing to explain the high volume of material errors, he basically came back with the "I didn't know the gun was loaded, the sun was in my eyes" defense. He said the results of him were basically he was filling out forms with which he was unfamiliar. Okay, let's suppose that you're running for a judgeship. You know that there's going to be a lot of interest in your judgeship. And you know very well that if you screw this up, there's not a chance in the world that you are going to get that judgeship. So, do you maybe talk to somebody and figure out exactly how you fill these forms out? Or do you just wing it? Supposedly, he winged it, and he got it wrong. The referee found Mirabal's explanation untruthful. He noted that Mirabal, who served as a closing agent on numerous real estate transactions, was not unfamiliar with reporting financial matters on forms, with ensuring accuracy and completeness on such forms, and as a result, that rendered his claims sort of unbelievable. Mirabal also claimed that he had until the end of the campaign to amend and correct his financial reports. And the referee said, yeah, that's true for errors that you may not have been aware of during the campaign, and you didn't become aware of until the end of the campaign, but if you knew about them, you had a duty to correct them at the time. The referee found that the errors were too numerous and far too politically advantageous just to be an accident. So he repeatedly certified these overinflated numbers in his campaign finance reports, allowing them to go uncorrected during the period when other candidates could enter the group race for judicial office. The referee then recommends that he be found guilty of violating Rule 4-84C. A lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. And then there's the Judicial Nominating Commission. Well, Florida has this thing where if you run for certain judgeships, you have to go through the Judicial Nominating Commission. And essentially what the Judicial Nominating Commission does is it sort of serves a function of screening different candidates. So he was trying to get a judgeship, so he went to the Judicial Nominating Commission, and one of those things that you have to do with this Judicial Nominating Commission is fill out forms. Again, Mr. I can't fill out financial forms right decided he would fill out other forms, and in much the same way. So, question 38 of the application asked whether Mirabal had ever been a party to a lawsuit, either as a plaintiff or a defendant. If the answer was in the affirmative, the application directed him to identify the jurisdiction where the lawsuit was filed, the style of the case, which would be like Mirabal versus XYZ Corp., the jurisdiction where the lawsuit was filed, and the case number, the nature of the lawsuit, and whether he was a plaintiff or defendant. In answering that question, he failed to list 6 lawsuits in which he was a party. He said, well, I filled this out from memory, and I guess I just negligently omitted those from his application. The referee found that Mirabal's explanation that he simply forgot about the 6 cases was not credible. The referee thus recommends that he be found guilty of violating Rule 8.4C. And then on question 39 of the application, it was asked whether a finding of probable cause or other citation has been issued against you, or are you presently under investigation for a breach of ethics or unprofessional conduct by any court, administrative agency, bar association, or other professional group. If so, give particulars. Mirabal answered question 39 in the negative, even though he was under investigation by the bar at that point for the errors in his 2018 campaign finance reports. When asked at the final hearing why he failed to disclose the pending bar investigation on his application, Mirabal stated that it was probably a mistake copy and pasting from a prior application he'd made to the JNC. Gee, you think? And this footnote's interesting. It said Mirabal was not elected to the bench in 2018, nor was he selected by the JNC to fill a vacancy in 2019. He was elected to the bench in 2020, but resigned 3 months after taking the bench when the bar ceased its investigation and the Judicial Qualifications Commission initiated its own investigation. The bar resumed its investigation following respondent's resignation. So he didn't actually profit from this, and he's really kind of the victim of his own shenanigans. You can almost see him back there thinking, I've got a way to keep these other scoundrels out of the race. And, he's, using the financial reports kind of like a marionette, adjusting and pulling the strings and trying to set it up so that he looks a lot stronger than he is, when, he should have just gone with what he had. If a better candidate beat him, oh well, that's the way life goes. But instead, he makes all these things, and as a result, he gets found out, it gets reported to the bar, and now he's in trouble for making false statements. And, lawyers can't do that. We can't lie. We can't lie, particularly in something like that that's material to our professional certifications and qualifications. So the referee, at the end of the day, found him guilty of all of these false statements. He did manage to escape liability for a couple of the things that the bar had charged him for because the court didn't find sufficient evidence of it. But everything else he was found to be liable for. He had done the wrong thing. And as a result, the question became whether or not he should be disbarred. And disbarment in Florida is a 5-year expulsion from the profession. You can't apply to come back in. Now, they do have something that's much worse, which is permanent disbarment, and permanent disbarment is for life. There's no coming back from that. But in this case, it's just for the 5-year disbarment. And so let's look at what they found. We looked to case law for guidance on how we've disciplined other lawyers, and they set up a number of different cases, Florida versus Kepke. In that case, Kepke denied that he had made a settlement in a personal injury case, and he hid the funds to keep his ex-wife from getting alimony, or his ex-wife-to-be. And it was found out by the judge, and they disbarred him, based on his willful lack of candor and the fact that he engaged in a pattern of deliberate dishonesty for personal gain. And they said, we see little difference between Mirabal's conduct in this case and the conduct of the lawyer. Now, I want to jump real quick to the actual oral argument at the end where his counsel is trying to advocate for him. And I want to point out something, and that is that it is a very, very difficult job when you have somebody who has clearly done the wrong thing. And what you're trying to do is salvage their career. And so you make the very best argument that you can. Now, a lot of people might think, well, this guy's just up there shining these guys on about, rehabilitation and that kind of thing. But what he's actually doing is zealously advocating for his client. I find absolutely no problem with what he's saying here. But at the end of the day, the Florida Supreme Court did not take up that issue. Let's watch.
A huge factor is that Mr. Mirabal has no prior discipline. It's a huge factor. And there are several factors that the court found and did not find. And it's going to be up to this court to determine and weigh those factors. And finally, the lawyers imposing sanction standard 7.1b allows this court to enter a suspension when a respondent knowingly does something. Mr. Mirabal admits that he knowingly did these things. And therefore, we respectfully request that this court impose a 1 to 3 year suspension because he can be rehabilitated. He can.
Well, counsel, let me say this: the rehabilitation issue comes into play primarily where we're determining that a disbarment will be permanent, and that's like go away, don't come back ever. This is not a permanent disbarment, is it?
It's not. It's
Okay.
10 years. A disbarment of 10 years is a huge.
5.
Okay. I apologize.
It's 5 years. So again, there would be an opportunity to show rehabilitation after the 5 years and to come back. So this is not where, if we decide to uphold the referee's recommendation here, we're not saying that the petitioner here is beyond hope and is beyond redemption. That's not what's being said. It's just saying that get out of the bar, and if you come back, it's going to be 5 years from now.
I don't disagree, but we all know there's a huge distinction between being disbarred and suspended, and the case law that we've cited supports a suspension and not a disbarment. Thank you for your time.
Thank you. We appreciate the excellent arguments on both sides, and we're adjourned.
Well, that's what I have for you today. It's a sad case, really. I mean, the guy just totally threw his career into the trash can and got nothing for it. I mean, it's really an unbelievably bad outcome based on pure stupidity. These are things that any lawyer who took professional responsibility in law school knows you can't do. You know you can't lie. You know you have to be completely candid with a court. If a court asks you a question, you have to answer it honestly. And if you don't know for sure, you have to say, on information and belief, I'm going to say this. And if you can't actually vouch for it and you find out later that that was an incorrect statement, you have to disclose that too. So again, it's really hard to find a lot of sympathy for Mr. Mirabal here. I do feel badly for him. He's going to be disbarred for a period of at least 5 years, and he'll only get back in if he qualifies for all of the things and under all of the rules that allow a disbarred lawyer to petition to become a lawyer again. So, again, that's what I have for you. Thank you so much for watching. If you have any comments, drop them in the comments down below. Like, share, subscribe, all that stuff. I always wait till the end to tell people that, because you know what? If you haven't liked this so far, then maybe you shouldn't. But if you have, I'd really appreciate the like. If you have the opportunity today, do something kind for somebody, then come on back down here tomorrow, join me at the beach, and maybe we'll do another one of these lawyers behaving badly.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.